We are recording. Good morning. Today is Tuesday, August 31st, 2021, and this is a public deliberation of the Baltimore County Board of Appeals in the matter of Donna Bair, 4607 Prospect Avenue, case number 19342 SPHA. We are here to deliberate a motion for reconsideration filed by an adjoining property owner, the Montañas. Requesting clarification that they thought was lacking in the order regarding the relocation of a portion of the fence to the rear of the fence and gate to the rear of the Bair house. So my view to start is that the Montañas did not allege any fraud, mistake, or irregularity, and didn't bring forth any legal basis that we should change our decision. I also think that we considered this location at our prior deliberation, and because there was nothing specific before us as to the prior location of the gate, we tried to give it a specific point of reference, which in the case of the order was the rear building line of the house itself. Mr. Belt, you have a view?
Well, I give a lot of deference to you, Madam Chair, because you were the pen, and that's always appreciated. And I remember, in this deliberation, I was somewhat concerned about trying to communicate the best that we could because we did not have a meets and bounds descriptions of locations. But the focus of our decision was granting various variance relief for requested relief. So we weren't doing a property line dispute and things of that sort on that side of the house. We were dealing with height, pursuant to conflicting statutes for different things. And the only reason that we made any alteration was for safety, as for a driveway portion that extended further from the house. So our intention was really not to mess with where the fence was other than the gate portion or any portion of that would impede sight lines for vehicles. So that was, for me, the goal of this. It was never our goal to change a whole entire fence back to where it was and things of that sort. I don't even know if that's within the purview of this board to do such a thing. So we were dealing with the height of which, and we made a caveat as to safety, and thus came the confusion. So the intention, I defer to you, Ms. Dobkin, is just for that portion that we're I believe, as you described, extending past the house line there, that would cause any type of problems when backing in and out from neighbors and things of that sort. So I defer to what the statement you just placed on the record. As Mr. Schmidt brought up in his motion, there was no evidence as to this location brought up during the hearing.
No party.
Yeah, so we really didn't have that. So I guess our faux pas was our intention, our good deed was trying to make a safety issue that made some confusion, but it was never our intention to alter this entire fence. It's just as to the portion that you previously described.
Mr. Pennington?
And based on everything I was able to ascertain so far from the case, obviously I wasn't here for the original hearing, but I do agree with Mr. Belt in that there was, based on what I've been able to read, there basically wasn't, I guess, enough information presented at the original hearing in order to make us, like you said, a specific, survey placement of the fence. And I agree with him, and I would give you much deference in this.
Well, I think where we've put it is someplace that can clearly be determined, because the corner of the house is the corner of the house. And it does move the fence back to provide a safe sight line and dimension, and I would deny the motion.
I would as well. I guess in our order from the denial of the motion, we can, in the language that we both can come up with, further clarify what our intention was in the first place, which I believe was clear, but perhaps by also including what we didn't mean. And
A good idea.
Yeah, and by doing that, if someone, code enforcement, were to be involved in the setting, they can clearly see what we did not mean by proving the negative, maybe. So that's my thought. Denial with further clarification to the best of our ability. But as for the remainder of the fence, we're not mandating any change, but for the portion that was previously stated, for the reasons previously put on the record during the original deliberation and here today.
I agree.
Okay, we're unanimous then. That would conclude this deliberation. And thank you, gentlemen.
Thank you. See you later
Thank
on.
you.
Ms. Honor, you can end the